Alvin Keimer.
Absent with cause.
Christine Brochu. Here. Keith Kyle.
Here.
Ellen Cornell.
Here.
Christopher Ullman.
Here.
Anthony Brunetti.
Here.
James Manning.
Here.
Mr. Chairman, you have a quorum with 6 members present.
Thank you.
You're welcome.
All right. This evening, we've got an appeal from Marcy, but
Yeah,
Steve,
so like we've done in the future, that's already in municipal court,
Municipal
so
court. Do you
I
need
would
any-
ask for a motion to
Okay.
table.
Okay. Chair would entertain a motion that we table Marcy.
So moved.
Second.
Motion has been made and properly seconded. Is there any discussion? Hearing none, all those in favor?
Aye.
Opposed? That motion carries 6-0. And also, Almonte is, Jill, that's going to next month, Ryan?
Yeah, he didn't notice in time.
Okay. So if you,
Yeah, a motion to
Motion.
continue.
all right.
Defer?
Chair-
Is it defer or continue?
Date certain of July?
Yeah, motion
Okay.
to move to a date, we'll do move to a date
Second.
certain
All right.
of July, whatever.
Chair would entertain a motion that we move Almonte to a date certain of July.
My apologies.
18th?
Yes, Mr. Chairman.
Thank you.
Okay.
Mr. Chairman, I move that we move Almonte to a date certain of July 18th for the hearing.
Second on motion.
A motion was made and properly seconded. Is there any discussion? Hearing none, all those in favor?
Aye.
Opposed, that motion carries. So if you're here for either Marcy or Almonte, they will not be heard this evening. So the only item we have is Eastside LLC. It's a continuation and it's down for a decision only. So at this time, I'm going to ask what is the board's pleasure in regards to Eastside?
Before we get going, there
LLC?
was one issue which was left open, was there were a couple of emails which weren't given to Ms. Morris, which were now given to Ms. Morris, and I didn't know if you had, just for the record, if you had any comment.
No, no
About
further
this.
comment.
No further. You did receive them?
I did receive them, Heidi sent them to me
Okay.
the next day.
Thank you.
You know, I have to recuse myself.
Yes.
Mr. Chairman, who's voting on this? I am not.
You are
It's
not
here.
It's the four, it's Christine, Keith, Anthony, and myself.
Correct. And then you should close the public hearing
All
now,
right.
because that was the one thing we left
So,
off.
thank you, Steve. Chair would entertain a motion to close the Eastside LLC public hearing.
So moved.
Second.
Motion has been made and properly seconded. Is there any discussion? Hearing none, all those in favor?
Aye.
Opposed, that motion carries 4-0. What is the board's pleasure in regards to Eastside LLC?
Chairman, members of the board, with respect to project summary, Eastside LLC, tax assessors plat S, lot 140, would make the following findings of fact. Incorporate by reference the project summary dated May 9, 2024, including the following documents that were submitted as part of the applicant's application for a 12-foot 35 lot width variance under section 6.4 of the ordinance. Following documents were relied upon as part of this decision. Letter dated January 5th, 2024 from the applicant's counsel. Letter dated January 4th, 2024 from the applicant's counsel. Letter dated February 7th, 2024 from Wayne Pimentel to the applicant's counsel. Letter dated February 8th, 2024 from zoning board counsel to applicant's counsel with various deed attachments. letter under date of March 19th, 2024 from applicant's counsel. Information that was in the packet relative to permits and tax assessor's records. Documents relative to the September 20th, 1994 zoning application and decision of the zoning board. Various complaints and a November 17th, 2022 notice of violation issued with respect to this property in question. The applicant's application, the building permit denial, expert report prepared and submitted by Pimentel Consulting on behalf of the applicant dated March 23rd, 2024 and April 20th, 2024. At the hearing held on May 23rd, 2024, arguments and legal points were proffered by the applicant's counsel, and the applicant called one witness, namely Edward Pimentel, who offered testimony on the record consistent with his two reports, which I just mentioned. In opposition to the application, there were submitted various letters of objection, and one witness, Judith Hay, testified at the hearing in opposition to the zoning relief requested. That would conclude my findings of fact.
I'll second.
A motion has been made and properly seconded to enter the findings of fact into the record. Is there any discussion? Hearing none, all those in favor?
Aye.
Opposed? That motion carries 4-0.
Chairman, members of the board, I would move to deny the requested lot width variance from section 6.4 of the zoning ordinance for the following reasons. Under the new state law provisions, lot width is allowed to be reduced in the same proportion as the existing lot size is to the required lot size. The lot is 45.4% deficient of the required lot size. The required lot width for the applicant's proposed use, that is a duplex, is 150 feet. The current street frontage is 69.54 feet. The 150-foot lot width under the new regulations is therefore 81.89 feet. Thus, the applicant is seeking a lot width variance of 12.35 feet pursuant to section 6.4 of the zoning ordinance, which will be addressed further in this decision. It appears, according to the deeds in the project summary, that the applicant's successor in interest purchased the property subject to a single-family use restriction, and that restriction is recorded at Book 321, page 257 of the Narragansett Land Evidence Records. It appears from the record that the recorded restriction was the contingent basis upon which variances were approved for an addition to the single-family dwelling totaling 4 bedrooms. In other words, this decision imposed a restriction on future use as a two-family, even though at the time a two-family was a permitted use by right subject to compliance with dimensional requirements. The applicant's position here with respect to the 1994 recorded restriction and zoning board decision is that because current law would not require a variance for building lot coverage, which was the relief sought in 1994, the 1994 variance is rendered moot, including the conditions which the zoning board imposed in granting the variance. The applicant asserts that this board is not required to defer to the 1994 decision and recorded restriction under the doctrine of administrative finality. Applicants assert, 1, that they are not seeking the same relief that was requested in the 1994 application, and 2, that due to substantial changes in state law, it was a substantial change of circumstance, namely in their argument that current law would not require the restriction imposed in 1994. In sum, the applicant asserts that the doctrine of administrative finality which would otherwise act to bar the relief requested, does not apply because the relief sought here versus the relief sought in 1994 is not the same relief, and that there has been a material change in the law between 1994 and today. I would move that the current, or find that the current application versus the 1994 application clearly does not seek the same relief. However, the change in the law that has not resulted in a substantial change of circumstance. Under both previous versions of the zoning ordinance, that which was applicable in 1994, and the current version applicable here, a two-family was permitted as of right, only subject to dimensional requirements under either version of the law. Some form of dimensional relief would be required. The difference being today that the relief necessary would simply just be less. There was no internal change in the project other than illegal construction, which parenthetically was specifically mentioned in Mr. Pimentel's first report, and then without adequate explanation redacted from his second report, to warrant lifting the restriction on that basis. As noted, while the zoning ordinance changed by eliminating the need for a lot area variance, two-family units were allowed in 1994 with a need for dimensional relief in 1994, and currently allowable, albeit with less relief. This is not the measure of a material or substantial change in the law that would necessitate a diversion from the finality of the 1994 zoning board restriction. I would move in part that the 1994 decision is not therefore moot, and the restriction imposed in 1994 is applicable. Notwithstanding that the 1994 restriction is applicable and would be dispositive of the applicant's application, I would, for the sake of clarity, also move that the requested dimensional variance also be denied, because, well, for a number of reasons. One, it bears noting that the planning board unanimously denied the application 5-0 and cited a litany of requirements applicants must prove to sustain the request for a dimensional variance. The basis for its reasons for denial are set forth in detail at page 6 of the project summary, and I would adopt as part of this decision in total the reasoning to deny the request for dimensional variance that was set forth by the planning board, notably that the hardship is not due to the unique characteristics of the subject property or structure, that the project will alter the general character of the surrounding area and impair the purpose of the zoning ordinance and comprehensive plan, that it is not in compliance with development and performance standards, that the project is not compatible with surrounding land use, nor does it protect the adjoining properties from adverse impacts. The site is not suitable for the proposed use, and there are available alternatives to the proposed use. Finally, the denial of the variance is not more than inconvenient, and the property retains significant beneficial use as a single-family residence.
A second.
A motion has been made and properly seconded to decline the request for a variance. Is there any discussion? Hearing none, all those in favor?
Aye.
Aye. Opposed? That motion carries 4-0.
Is that it? What about the request for the material change? Is that subsumed within the decision?
We need to vote on that separately. I mean, I could have just ended it there, but I thought for the sake of clarity that we should address the other issue as well.
Correct, I believe you voted on both issues there. I'm satisfied with
Okay.
Thank you.
Cool.
Thanks.
Jill, what do you have for us this evening?
Jim, I have one more update.
What's that?
I do. It's about you. Heidi went through some serious legwork. We pulled out some stats on you. Today is likely your last meeting, so I just wanted to let everyone here and all our YouTube fans know how much work you've done in the last 22 years.
Wow.
You became chairman in 2012, so you've been chairman for 12 years. Jim, you've been chairman for as long as I've been here. You're the only chairman I know in zoning.
So, your first meeting.
My first meeting was your first meeting.
Yeah.
Mhm. You attended 361 meetings, give or take a couple. I can only think 2 times in the last 12 years you're absent. Those meetings generated 1,276 projects or public hearings. Your value to the town, to the
Thank you, Mr. Chairman.
Thank you, Mr. Chair.
Thank you, Jim. Thank you, everyone. It's been a pleasure. It's been an honor. If they would have me, I would certainly stay on, but I understand the people have spoken, so. I do feel, first of all, I guess the staff, it's been tremendous working with you guys. It's been, I've enjoyed every minute of it. And I do feel very comfortable leaving the board with such an outstanding cast of characters. I think it's, you know, I think if you look at our track record, we haven't lost many in court, I don't think, have we? Steve, we're pretty,
No.
we're pretty good when it comes to that, so. But it's, like I said, it's been an honor and a privilege, so. That's about it. I will miss all you guys. I don't know what I'll do with my Thursdays, once a month, sometimes twice a month.
Exactly. Some of those meetings that Heidi pulled up, 23 meetings in a year.
Oh, I've got a little more detail.
How many do we have on the break? I had it at 26, just on the break.
Probably, between all of the appeals. That went out for years. Mhm. Mhm.
You know.
In 2003, you had 24 meetings.
No, Rick was in 14, 15.
My favorite was the Zoom meetings.
Oh, those were fun.
But I guess for the last time, the chair would entertain a motion to adjourn.
No, we're not.
No one's making that motion. You better make it.
Can't make it.
All together,
What
guys.
about public commentary?
Well, we're gonna be on YouTube all night.
All right. With what I'm looking for, trepidation, regret, I move we adjourn. Come on,
It's not supposed to be this
Yes.
difficult.
We're gonna miss you, Jim, for sure.
Thank you, Chris.
I
Definitely.
can't thank you enough for everything that you've done during my tenure here. And I know that everybody else feels the same.
Thank you.
Yeah, so before you,
So with the heavy heart, I'll second that motion.
before you do take that vote, I've probably been with you the longest through the folks that are here. You've been a tremendous mentor, a tremendous example. You're probably the most honest and fair person they've ever met. You've treated every one of these that I've been with you, every one of these hearings with the utmost respect for all the people. So, we are going to miss you. I am going to miss you at least.
Well, I'm sure that will carry on. You know, I mean, I served with some chairmen. I served with some good ones, and I served with some, and I see Jerry's in the audience, and she'll tell you there were a few that did not respect the people that came before us,
Yes,
right?
and I'm here because you were
Does
the
she
one
need to
with
be
us.
sworn? Steve, if she's speaking. But I always vowed if I mean, I learned from Donald, he ran a very good meeting. And that always stuck with me. You have to, I mean, people are here with, it's a zoning, we're a board of relief, you know, and if we can grant it and it's reasonable, we should help people. You know, we don't always make everyone happy, but that's
Unfortunately, part of the board.
yeah. Somebody's gonna do the
Heavy lifting.
heavy lifting, right? So, I mean, we had, that meeting was last week. Was it last week that we had, of the
We did, yeah.
chairs of the various boards?
Yes. Mhm.
And my comment was that I was listening to all the boards, you know, the chairman and what the boards do, and, you know, my comment was that I kind of felt out of place because we're not a proactive board, we're a reactive, you know, everything just comes to us.
We're the last, we're the
Yeah,
last
why
person.
You know, so, but all I can say is just keep up the good work. You know?
Will do.
All right.
Thanks, Jim.
Okay, we didn't vote yet.
All those in favor of adjournment?
Aye.
Opposed? That motion carries 6-0. You say no?
I'm not gonna.
Okay. We are now adjourned.